We're going to start with Plenary 1. The Plenary 1 presentation will be done by Judge Benita Whitcher. She will be dealing with the interesting labor court reviews, including learnings and matters for consideration by commissioners, and the transition from the CCMA hearing room to the labor court. And I think Judge Whitcher is the right person to talk to us about this. Because prior to going to the labor court, when she was appointed in 2014, prior to that, she was a national legal officer of NUMSA, as well as the part-time senior commissioner at the CCMA and the bargaining councils. She lectured and supervised master's students in the law of evidence and labor law at the University of KwaZulu-Natal. She has published various articles in law journals and co-authored various textbooks on labor law and the law of evidence. Judge Whitcher practiced as a public interest candidate attorney at the Labor Resources Center and as an attorney specializing in labor law at Channels Albertine, Tainer, and Brent Pardon attorneys. Judge Whitcher holds a Bachelor of Journalism and Media Studies from Rhodes University, a LLB and LLM from the UKZN. Ladies and gentlemen, please give a round of applause and welcome Judge Whitcher. Thank you very much. Yes, thank you. Thank you. Thank you very much.
I'm going to find my spectacles. A lot has happened since I saw many of you. I'm now gone old and blind. Well, I heard with interest that you have quite a number of interesting guests here, snakes and all kinds of things. So try and not take any selfies with the snake. If you need any help, I live in Westville, and my backyard is essentially a nature reserve. So I have snakes, bats, monkeys, birds, rock rabbits, dogs, cats. So if you need any help, you can just call me. All right. Well, I must say good morning, everyone. Good morning, Director Morejane. I don't know if he's here or where he's sitting. Good morning, sir. Or should I say Mora? Good morning, commissioners and other guests. It is truly an honor to speak to you today. The CCMA is one of the most important institutions in this country. You have the overwhelming task of advancing labor peace and bringing fair labor practices to the workplace. And from my studies, you are really doing a tremendous job. Unfortunately, I just read in the newspaper the other day that your workload may increase by about 25% because of the new legislation. You have my sympathies. Well, it's the same at the Labour Court. I was just explaining to them today that at the Labour Court, obviously the courts are divided into trial courts and motion courts and urgent courts. We have 3 different courts. And I'm in motion court this week, and because of the load, the JP could not release me for the whole day. So this morning I had to do an urgent at about 8 a.m., and then I've come to give my presentation, and then I'll have to leave. My court will start at 1 p.m. And I have like about 3 reviews waiting for me. On average, in motion court, we deal with, well, this is no exaggeration. On average, in a week, when I'm in motion court, I deal with at least 8 reviews. This is besides all other manner of applications in a motion court, right? With very high, long lever arch files. But the main problem does not lie with the CCMA. From what I can see, the CCMA generally is doing a good job. The main problem is because people misunderstand, or choose rather, to misunderstand the test on reviews. They misunderstand the function. What is the function of the CCMA? The function of the CCMA is to deal with the substantial merits of a matter, cut through all the unnecessary claims and counterclaims, and essentially go to the real dispute and resolve it in a simple and quick manner. You're there to provide simple and quick justice. It therefore follows that your awards cannot be assessed and approached as though you are writing some judgment in the High Court or the CCMA. Under the circumstances under which you work, and also because of the test, errors will be made, because it's not a science. So the errors will be made regarding factual findings, reasonings, and so on. That's part of the unique job that you have been given. And therefore, that is why, which I'm going to explain later, that is why the test on review is highly important. Unfortunately, many people do not fail to appreciate this, and our courts are still flooded with reviews. I can tell you 80% of them are not successful, because at least 80% of them have no merit at all, or they completely misconceived the nature of a review test. But I have digressed. I was still talking about why it is an honor to speak to you today. And as I've said, it's because the CCMA is one of the most important institutions in this country. But it also makes sense for the Labour Court and the CCMA to come together and discuss ideas, considering we are bound together by reviews. But my visit is also special because part of my growth obviously came from working as a commissioner. And in fact, two of your commissioners are also very special to me. Mr. Prashortam, I don't know if he's here, known as JP, and Richard Lister. JP and Richard Lister, together with Judge Nicholson, were actually my principals when I first graduated from university. And as a green graduate, I went to do an internship at the Legal Resource Center and later articles. They, together with Judge Nicholson, JP and Richard Lister and Nicholson, were the best mentors, generous in their knowledge, patient in their guidance, and of course topped with lots of humor and good wit. What is very important for a lawyer in her formative years is not to get their confidence bashed in by bad mentors and prejudice out there. And I know the reality is that this often happens, especially with women. On the other hand, I can say I was lucky. As I said, I started at the Legal Resource Center, where I had tremendous mentors who did nothing but encourage and develop me. I left there with a good grounding in admin law and civil procedure. Civil procedure, of course, if you are a lawyer, many matters are fought and lost just on civil procedure. The Chief Justice made a comment recently. He says that what the public does not always appreciate is exactly what it takes to effect transformation. What gets missed, he explained, is that many women and black lawyers do not get the high quality work, they need to develop their forensic skills. And as I said, I was lucky enough, throughout my career, I was lucky enough to work in firms and institutions who took time and who made it their task, the important task, to make sure that I develop in that manner. And in this regard, I also wish to thank the attorneys at Channels, Albertine and Tanner, and Brett Purdon. Essentially, I work with the best, and they provided me with the grounding I needed to move to the bench. My visit today, before I get to the matter at hand, I just want to say one more thing. My visit today, however, is with some sadness, because it is without my good friend, Brenda Grant. She was a very good friend of mine, a wonderful mother, beautiful soul, an indescribable loss to her daughter, and I'm sure many of us. So, with that, I'd like to dedicate my day to her today. So with that, I will now turn to the business at hand, reviews. Where's the green? This is the green.
Yeah.
So where do I see it? Do I see it? Okay. Now, I'm not going to bother you and go into, I'm sure you'd know that for many years, between 2010 and 2012, there was a great debate about the approach in reviews. What is the actual test in reviews? So we had Sidumo, then followed that with Herholt, and then Mofokeng, and so on. However, for me, the judgment and for which sets the matter out in a straightforward and simple manner is the judgment by my JP, Wagley J, in the case of Goldfields. Obviously, Goldfields is consistent and agrees with Herholt and Sidumo, so you don't have to worry, he's not taking a different approach. All he has done is essentially taken all those arguments and reduced it to a simple, easily understandable concept. And so what I've done from that judgment, I've extracted the following extract, which I think is important for commissioners. And in that extract, Wagley says, in a review, the questions to ask are these. Did the arbitrator identify the dispute she was required to arbitrate? This may obviously only become clear after evidence is led. Did the arbitrator understand the nature of the dispute he was required to arbitrate? Did the process that the arbitrator employed give the parties a fair hearing on the issues? And is the arbitrator's decision one, which is underlined, that another decision maker could, not would, could reasonably have reached based on the evidence? So if we turn that around for arbitrators, what I suggest based on this extract is that when an arbitrator is conducting an arbitration and drafting an award, during that process you need, at the beginning of the process and the end of the process, you should ask yourself the following questions. Am I identifying the true dispute between the parties? Do I understand what is the real nature of the dispute before me that I have to determine? Am I conducting these proceedings in a manner that is giving the parties a fair opportunity to lead material evidence and to canvass relevant issues. And then, once you've drafted your award, ask yourself, put yourself in the place of someone who may want to review it, and then ask yourself, is this decision one that one fellow decision maker could reach based on the evidence? So the important thing is really, is there a connection, is there a rational connection between my decision, final decision, and the evidence before me? Is it supported by the evidence before me? Or is it completely disconnected? Have I gone on my own speculative rave? So those are the questions that an arbitrator should ask themselves. Now, I'm going to deal with these aspects individually and look at certain and deal with them through certain cases. A very important case for me is this case in Hospersa Shambi. It's not a very new case, it's quite a few years old, but it's an LAC case by Sutherland. And this case illustrates why it's very, very important for arbitrators to understand, identify, and resolve the true dispute between parties. Why it's important? It's important for jurisdictional purposes, to make sure that you have jurisdiction, for the parties to lead relevant evidence, and for the arbitrator to apply the correct principles to the dispute. Because you'll understand that certain disputes have certain characteristics and requirements, and different principles apply to them, which will be illustrated later on in another case. Now, I'll leave, oh gosh, I'm turning the wrong thing. You can see since I've been at the bench, my tech skills have gone down. Well, just as an aside, I was sitting and listening to your IT people, your experts, and I was actually quite envious. Because, believe it or not, because we actually a government institution, so we are at the mercy of government institutions. And therefore, believe it or not, it's not uncommon for us to have no emails for 2 weeks, no internet for 2 weeks, just like everything just comes to standstill. The phones, whatever. As for having an app where our litigants can go and track their case, whoa, gosh, let me not even dream about that. It's like, I don't know what age we are working in there, Dictaphones. When I was a lawyer, I did a lot of work because I had a dictaphone. Dictate, you got secretaries that type, they are trained in that respect. Nothing there. You type your own stuff. So every judgment I do, I type from scratch to my head. Well, they've given us Dragon. Oh, gosh. You have to fight with Dragon. Because I keep saying, you're not recognizing my voice. I have to keep teaching it to recognize my voice over and over. It keeps saying, who are you? Then I just say, I really got no time for this. Wait. I'll do the old way, let me type all these long stack of judgments there. That's how we work, because you are lucky that you are an independent organization with your own budget, with your own thing. You can run yourself. If only we had that luxury. But anyway, back to the relevant issues. Now, we were talking about why it is important to identify and resolve the real dispute between the parties. And this case, Hospersa, illustrates this point. a judgment by Sutherland. I like Sutherland. All the judges have their own little styles. Some are quite interesting to read just for the style. Wagley, my JP, why I like his judgments, I'll give you a piece of advice. If you really are looking for something, log in his name. Wagley writes one of the judgments in simple, straightforward manner. Well, anyway, this is one by Sutherland. He's the witty one. Now, the facts, let me just explain the facts in this matter for you to understand. What happened in this case is that Mr. Shambi was dismissed in around about 2010 or 2011 or so. But before his dismissal, he had been on suspension without pay for about 9 months. After his dismissal, he referred a dispute to the CCMA, was a bargaining council, and in his referral, he described his dispute as follows: a dispute concerning the interpretation and application of a collective agreement, because the collective agreement regulated the suspension and the issues of discipline and suspension, precautionary suspension. He referred this matter 692 days after his suspension ended. So not surprisingly, when the matter comes before the arbitrator, the respondent raises a point and says, this dispute is an unfair labor practice dispute. His complaint is about a suspension, an unfair a suspension without pay. It's an unfair labor practice dispute, and he was supposed to refer his matter within 90 days of the commission or omission of the alleged unfair act. And clearly, 692 days is clearly long beyond that. Mr. Shambi argues, his lawyer argues, no, this is not an unfair labor practice. This is a dispute that relates to the interpretation and application of a collective agreement, because the suspension is regulated by the collective agreement, and therefore it's a Section 24 dispute. And Section 24 does not have time periods. There's no statutory time periods connected to these disputes, and therefore my dispute is not late. And if any time period may be relevant to my dispute, then it's the Prescription Act. The Prescription Act gives me 3 years. I'm claiming money, essentially, so 3 years has not lapsed. The arbitrator accepts that argument. He says yes. So he resolves it. He approaches the matter as an interpretation, application of a collective agreement. And he accepts that there are no statutory time periods applicable to these disputes, and therefore, in the absence of that, maybe the Prescription Act will apply, and since 3 years have not elapsed, the case before him is, the case before me is properly before him, there's no need for condonation. And he hears the matter, and obviously he finds in favor of Mr. Shambi. Right, the matter comes on review and then ends up in the LAC before Sutherland. And then Sutherland, in a very sarcastic manner, takes the thing apart. I think sometimes he enjoys himself. And then he says, so I've just extracted certain part of it. Try to leave out all the dripping sarcasm, because, right. And then he says, the idea, a breach of a right that derives from a collective agreement is not automatically a dispute contemplated by Section 24. In this dispute, what is the real dispute? His complaint is about a suspension, right, which is an unfair labor practice. The fact that that right is in a collective agreement does not make the collective agreement, the dispute, the nature of the dispute. And as Sutherland pointed out in that judgment, he says he looked at the record. He found there was no dispute about the interpretation of any about any clause in the agreement. Everyone was in agreement about what the agreement means. If there was no dispute about whether the agreement can be invoked, everyone was in agreement that this agreement binds us all here. It binds employer. So where's the dispute about an interpretation, application of a collective agreement? All right. In this situation, the collective agreement was merely an item of evidence. It was basically, my complaint is a suspension without pay, and this collective agreement is merely an item of evidence that supports my claim that it's an unfair labor practice. The collective agreement is not the dispute. All right. And why he did this judgment, and I agreed with him, he said because he's tired of commissioners mixing these things up. Because we often find that many disputes are determined as interpretation and application of collective agreements when they are not at all. So the important thing here is that what he was also sarcastic about was that he said this commissioner just slavishly adhered to the applicants telling him what the law is. You must decide that, you don't, very often they mischaracterize their disputes, right? So you must interrogate whether that dispute they claim it is objectively the dispute that they claim. Even if that sometimes it requires evidence to be led, right? For you to actually come to that decision. And so what the principle in the end, he says that in misconceiving the nature of the dispute, the arbitrator's decision was influenced by incorrect law. Right. Now, sometimes you'll see now with the review test will show you that sometimes even when an arbitrator makes an incorrect or misdirects himself or commits such an irregularity, sometimes it does not necessarily mean that the outcome, it does not necessarily mean that the award is liable to be set aside. And this is what Wagley again. This is again Wagley's case. He's a very sensible judge. He's got a very common sense approach to things. Right. So in this case, this was also one of the matters where the arbitrator had misconceived the nature of the inquiry before him. He was required to determine a dismissal for misconduct. However, he incorrectly approached the matter as a dismissal for poor performance. Now, that was wrong because the requirements to show that a dismissal for misconduct is fair is different to the requirements to show that a dismissal for poor performance is different. These are two distinct, poor performance and misconduct are distinct, diverse concepts. So he misconceived the nature of the dispute. However, and this is the beauty of reviews, of the real test or the approach, however, in reviews, even if we find that the arbitrator misconceived the nature of the dispute, he determined the wrong dispute. The question on review is the arbitrator's award, because the arbitrator found that the dismissal was unfair, is the arbitrator's award nonetheless one that could be arrived at by a decision maker on the evidence? So even if so the reasoning of the commissioner, the route that he used to get to the end result, sometimes is not a reviewable, a materially reviewable offense. And it's not enough to set the award aside. The question at the end of the day is whether the evidence on record nevertheless justifies that end result. Right. In any event, the argument would be, in any event, the evidence shows that he was guilty of misconduct. Even although you approach the matter as a dismissal for poor performance, it's fine, because in any event, the evidence on record did show that he was, in fact, guilty of misconduct. So we won't set the award aside. Right. But of course, in this case, the court found that it was still liable to be set aside because the evidence on record showed that the employee was guilty of serious misconduct. So if we go to the next slide. Now, this is sexual harassment. Now, why I chose this case is because it's a very long case. It's by my brother, Totlo Laumache. He went on, it's quite a long case, he went on quite a long rave. I think he was very angry in this award, justifiably so. So he decided, I am now going to spell out in detail the approach that arbitrators and commissioners must follow in sexual harassment matters. Now, obviously, the judgment is so long and it says such a lot, I had difficulty trying to just extract certain relevant points, Now, so what I've done, I've just started off by extracting the commissioner's finding, part of the commissioner's finding, and this is what the commissioner said. Finding was, I am persuaded that the applicant made sexual advances towards the victim, but that, however, he was encouraged to continue doing so by the docile conduct of the victim, and consequently that such conduct did not amount to unwanted sexual harassment. Well, he said a lot of other things, but I mean, I'm not here to for drama. And just, out of respect, I don't want to be saying too many other things, but you're going to read it for yourself. But why I just left that one. What I want to point out, what the Labour Court says, and which is very important. The Labour Court realized that also in this judgment, we've got two codes. There's the 1998 code, and then there's the 2005 code. And what he found is that people are still in the 1998 code. Right. The 2005 code, why that was drafted and amended, because they found a lot of problems with the 1998 code. The 1998 did not actually take into consideration the realities, certain realities that happen in sexual harassment. Right, so for example, as the court says, on the plain meaning of item 4 of the 2005 code, there is no requirement that the accused employee, I use EE for employee, that the accused employee must have been aware or should have reasonably been aware that his conduct was unwanted, or that the recipient must have made it clear that the behavior is considered offensive. So the 2005, he says, the 1998 code placed an onerous burden on the complainant to prove the harasser's state of mind, and to also prove that he or she had at all material times, in unequivocal terms, made the harasser aware that the conduct was not unwelcome. Now, in the 2000, has a more objective approach, which is in the context of this workplace, in the context of this relationship, in the context of your job, this kind of behavior objectively is sexual harassment. There's no need for the victim to go and say, please don't, or to point out the obvious to people. In other words, employees have to self-regulate, self-monitor. You must decide whether your conduct is acceptable or not. And the other point that he was making is that, in the workplace, there's nothing wrong with relationships developing. I mean, funny enough, he has a point, because many of us with our very busy schedules and life, I mean, where do we really meet people? But he pointed out there's nothing wrong with that, with clean, whatever, thing fun. But don't see the workplace as your hunting ground. That's the difference. So there the line is drawn. So the law, we are not outlawing relationships, but there's certain protocols that needs to be followed. Okay. And then the other thing that he pointed out was that the commissioner in this case also misconceived the standard of proof. And in the last line, the judge says, to require direct evidence in such cases as the commissioner sought to do is to set the standard of proof too high, a reviewable irregularity. Well, yes, he was requiring like really hard evidence. He forgot that the standard is probabilities. Is it probable, more probable than not, that this happened? Is it probable that such an event may have happened? Not whether it in fact happened, whether it did happen, whether it's very probable. I'm going to come to that issue of standard of proof because, as a general concern, because that's also one of my concerns, well, most of our concerns in awards. People tend to forget the real standard of proof, and they think that they're running criminal trials. Well, let's put it this way. Let's go there straight away about standard of proof. Hope I can remember how to use this thing now. Oh, now I have to go forward. I don't know if I'm pointing in the right direction. My son calls me a techno peasant. Anyway, quantum of proof. Now, there is a wide spectrum you have to, I think you need to acknowledge that there's a wide spectrum of degrees of conviction that can happen in a certain thing. One can say that the happening of an event was reasonably possible, more probable than not, very probable, almost certain. Make sure that you are using the correct one, right? In labor law, it is sufficient that the story of the party bearing the onus should be more probable than not, right? And probable, what does the mean of probable? Probable is really having a chance of happening or being true. So, and in this, the arbitrator does not have to be certain that the other side is not telling the truth. To find one side's story probable, it's not a requirement for you to hold the belief that the other side is telling lies. Each side, the one with the onus, merely has to prove that his story is more probable. That's all. And the employer must prove his own case on a balance of probability. And what I find, sometimes when you're assessing evidence, you may say it's not that simple, but I find that sometimes it is simple. You can look at all, you can identify what are all the facts, what are all the proven facts in this case, right? And then you can ask yourself, right, I'm trying to work out whose version do I believe? And it's possible to try and identify factors which lessen the probability or increase the probability. So ask yourself, okay, what are there any factors in all this evidence that lessen the probability of this party story? Are there factors that increase the probability of this person's story? I was dealing with, I'm not going to mention the names yet because, no, well, I can, I handed down the judgment already. I was dealing with a matter recently, and the person was dismissed for, she sat on a selection inquiry as one of the panelists. After the selection inquiry, she wrongfully deposed to an affidavit in some other arbitration, unrelated to the selection process. She posed to an affidavit in which she said that the minutes or the report of the selection committee were changed after the process, and they did not reflect what the panel had unanimously agreed. All right. Now, at the arbitration, one of the issues was whether, there were a lot of other issues, but one of the issues was whether she was telling the truth. Because she had to, now, the evidentiary burden was on her to establish that she made it justifiable, that she justifiably breached her obligation of confidence. And the arbitrator finds as follows. The arbitrator says that, so the person who was the chairperson of the panel, of the selection panel, and one other panelist came to testify for the employer. And this lady, let's call her Jacobs. Jacobs testified on her own behalf. So the arbitrator says, the affidavit she made was not true. Why it's not true? Because so-and-so, Buthelezi and Dolashi, testified that the minutes weren't changed. Two people testified that the minutes weren't changed. Right, so because they testify that, and because two people testify that, that was sufficient for the arbitrator to find that the minutes weren't changed. Now, I look at this thing, and I'm thinking, if you look at this, there was sufficient objective evidence which highly increased the probability of Jacob's version, and at the same time decreased the probability of Buthelezi and Tolani's evidence. What was this? Independent of oral subjective evidence, there was documents that arose from the selection process. Now, what Jacobs had said was that from her recollection, the selection committee had decided to choose the best candidate, Mrs. van der Merwe. However, the minutes when she saw the report, another Miss X was chosen. But when you go to the documents, I just felt that the documents supported her thing, because the documents clearly indicated that, number one, this was not an affirmative action post. The shortlisted candidates were subjected to a hard computer test. The job requirements specifically set out you need to know hard-cat program. 90% of your job is you're going to deal with that. And you need to know X and Y, quite a number of things. And the candidates were subjected to this test. Right. Ms. van der Merwe, scored 100% in practically everything. The person who was, the other person who the selection committee said was who was eventually selected, she scored like 22%, an outright fail. But then they subject the people to interviews. And interviews are much more subjective. The scoring is much more subjective. It can be more manipulatable, obviously, we all know, because each one is looking at them and putting down a score. But that's clearly. And so with the interviews, Miss X scored 60%, and Van der Merwe scored 57%. Like there was a 3% difference with the interviews. The final report says that the recommended candidate is Miss X. Right, the one that scored 22% in the hard-CAD test, which is like the core job, and the one that scored only 3% more than the one that earned 100% in the interviews. So, to my mind, there was all this objective evidence which clearly heightened the probability of Jacob's version. And there were a whole lot of other things. Because the point is, it made absolutely, absolutely no sense. If that panel considered itself a rational, fair panel, then they would have recommended Van der Merwe. The other concern is the shifting evidentiary burden. Now, what a lot of arbitrators seem to forget is that unlike the overall onus, an evidentiary burden may shift during the arbitrations and be transferred in the course of the arbitration, depending upon the measure of proof furnished by one party. It can move up and down, up and down, up and down between the parties. So obviously in a misconduct case, the evidentiary burden starts with the employer. But once the employer provides prima facie proof, in other words, once it has fleshed out its version with sufficient evidence that requires an answer, the evidentiary burden shifts to the employee to provide his own defense. And on raising a particular defense, an evidentiary burden falls on the employee to establish his or own version is likely. Right. It is not necessary for the employer to adduce evidence to disprove positively a defense of an employee, especially if the defense is the employee's and within his own unique knowledge. Basically, each party must prove their own case on a balance of probabilities. Right. So why I'm putting that in is just for people to be aware of these principles. A very important thing is that sometimes parties, you need to be aware that sometimes parties are unskilled in the art of evaluating evidentiary burdens and their burdens. So during the arbitration, the arbitrator may have to make piecemeal evaluations of which party bears the evidentiary burden at all the different stages in order to advise a party that a certain witness or evidence or documents needs to be brought or given, right? So just to go back now to, we diverged there, but I just want to go back to some of the Labour Court judgments which I think are important. I'm sure many of you, there's been a titter about judgments regarding a competent verdict. Have you come across that? I think it's very important to just change things a bit. Right. Really, really, competent verdict, or whatever, in simplistic forms, is a situation where an offense, an employee, is an offense an employee may be found guilty of if the original charge is not proven. Right, so an employee may be charged with X, but the evidence proves another offense, something connected or similar, so on. But I don't think the offense convicted of can be more serious than the original charge. And obviously the sanction cannot be higher than the sanction that would have been applied to the original charge. But let's just look at this case. This is the LAC case. This is, I think this is also one of Wagley's cases. The question in this case, the employee was charged for dishonesty, but dismissed for negligence. Right, so he was charged for dishonesty, he went to a disciplinary inquiry. At the disciplinary inquiry, the chairperson said, oh, you know, the evidence doesn't really show dishonesty here. It seems to show rather negligence. And he found him guilty of negligence and dismissed him. It came before the arbitrator, and the arbitrator's position was, and believe it or not, also the Labour Court confirmed the arbitrator's reasoning. The arbitrator said that so the question before the LAC was whether the arbitrator acted unreasonably in concluding that a finding of negligence was not a competent verdict under the charge of dishonesty. Right. So the arbitrator's position was, look, this man was originally charged with dishonesty. There's no evidence of intention or real dishonesty here. Yes, the evidence shows some shows negligence on his part, but I'm going to find his dismissal unfair, substantively unfair, because the charge with which he was actually charged with was not proven. And therefore, he can go. So the question before the LAC was whether the arbitrator acted unreasonably in making this decision or reasoning in this way. And the LAC stated, it explained, obviously they need to explain the context. And where does the reasoning start? The LAC said that an employer is not expected to frame a charge sheet as one would prepare a criminal charge. Right. It merely needs to set out in sufficient detail the allegations, the where, what, who, when, that constituted the misconduct, so that the employee is aware of the case he or she is required to answer. The categorization by the employer of the alleged misconduct, the label put on the misconduct is of less important. What is important is the allegations in there. Don't worry too much about the label. Worry about what are we actually saying he did. And as the Labour Appeal Court pointed out, it is not uncommon for an employee to, for example, be charged with theft and for the evidence at the disciplinary inquiry or the arbitration to establish an offence of unauthorized possession of property or unauthorized use of company property. There's nothing wrong with that. So, NB, the principle that arises out of this case is that there is no requirement that competent verdicts on a disciplinary charge should be mentioned in the charge sheet. And it is reasonable for arbitrators to find an employee guilty of a charge, of a competent charge. If he's charged with theft, there's nothing wrong with charging him with finding him guilty of unauthorized possession or something. If he's charged with, I don't know, where you look how far it goes. In this case, the man was charged with dishonesty, but he was dismissed for negligence. And in this case, the LAC set aside the award, not only because the arbitrator used the wrong principle, but also because the facts did show that, in fact, Danny was guilty of serious negligence. And therefore, it was justifiable for the employer to find that the employment relationship could no longer exist. So in other words, the question is the evidence on record justifiable for a dismissal? The only qualification is whether the employee was prejudiced in conducting his defense. But he can't be prejudiced if he knew the allegations, the specific allegations of the offense. Right. Now, there's another case. I think I'm running out of time, but I just want to point, I'm not going to deal with this case, but just read this case. This was one of my favorite cases for the year. It gave a lot of discussion at the tea room. SAPS thing. This one also deals with competent verdict. A policeman shot and killed a person at a social function. The SAPS, unfortunately, I don't know why, they think they're in some criminal matter. They draft a charge, like they're drafting a charge in a criminal court. And they've got murder, and they essentially, they charged him with murder. Hey, I don't know who advises them. But anyway, so they charge the man with murder. They get to the CCMA, and the arbitrator says, no, man, there's no evidence of murder. And he goes into this long thing, what does murder mean? What does culpable homicide mean? And what does, he's like acting like he's in the criminal court. All right. And then he says, no, there's no evidence that, there was this deliberate, intentional, planned, he's going through all the elements of murder. The elements of murder does not exist. There is evidence that there was an unjustifiable killing, some sort of negligent killing, and all. There is evidence of a wrongful killing. But the evidence doesn't show murder. Therefore, your dismissal is substantively unfair. Goodbye. Yeah, and at the same time, you will get reinstated, and I'll give you full back pay. So, obviously, the matter came before the LAC, and the same reasoning that I was talking about earlier on, about competent verdict, applies here. Right, so the LAC said, it doesn't matter about the label. You distracted yourself by concerning yourself about murder and elements of murder and all that. All you needed to concern yourself was there evidence before you that indicated some kind of unjustifiable killing, some kind of thing. The man killed someone. If there was no good reason for that, that's sufficient. Right, and then obviously they overturned. My time is up now, I think. There's a lot of other matters. I'll just leave it. I just want to look at... Oh, sorry. There is one. I'll leave the rest here with you. Just one more thing. Jurisdiction. I just wanted to point this out. A lot of people may not realize this. Where new facts, sometimes you make jurisdictional rulings, where new facts come to light after a commissioner has made a ruling declining jurisdiction, the commissioner has a duty, is bound to correct that obvious error in his ruling if new evidence comes to light thereafter. So you have that power. You can't say, well, I'm nomino officio or all those things. Wash my hands, I'm over. All right. Another important thing that I wanted you can read on your own, and they can maybe give you a very important case came on, because you deal with this, I see you dealing with this quite a lot, is what constitutes a temporary employment service? I'm sure lots of people are coming to the thing and saying, I am employed by a temporary employment service, labor broker, and I want to be deemed to be an employee of the client. You're getting lots of that, I'm sure. All right. So I won't read out this case, just look at it. It's a very difficult case to read, long and complicated. And so what I've done, I've tried to set it out in a simple way. So the issue lies in the interpretation of the definition of a TSS. Right? And very importantly, the thing that he highlighted there is that why these people could not be deemed to be employees of the client was because, in fact, they were, not working for a labor broker in the first place. Because let's call the labor broker, let's just for convenience sake call him, C-Force was not providing labor to ship for the purposes of pursuing ship's business. So he wasn't providing labor to ship. What he was providing to ship was a service, his own service. He was running a pallet service. So his employees were going to different clients and doing a pallet service. So he was providing a service, and therefore, I mean, let's put it this way, the judgment is so long, but it really just boils down to this. So I suggest you just read it. Just very quickly, before I go, this is not going to be a speech, but can I just say, as I said, I think you are doing fantastic work under the very trying circumstances you're doing, but there's just one or two things. What I'd like you to do is, I see that people, you've got these guides, the CCMA guidelines or rules in misconduct arbitrations. And what I'm noticing, it doesn't seem like people are complying with it. So it's very important. One of the very important things is to try and narrow issues. And why that is important, because in the end, it will affect whether you conducted these proceedings fairly, in a manner that allowed everyone a fair hearing. Because when you narrow the issues, now, all parties, because there's no pleadings, so all parties at the beginning should be aware of what are the issues here. So, for example, the employer should be aware of what exactly is the complaint of the employee. All right. So, for example, the employer comes there and runs a case. Next thing, the employees got various issues which they did not know about, and they did not have an opportunity to prepare for and lead evidence. And the commissioner, it did not occur to the commissioner to see that and say, right, let me give you an opportunity to do that. Okay, and here's my one problem. This is one of my pet complaints, is that what I find very often is that parties will come before the commission in arbitration, and parties are very, 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 very quick to fob off, discard jurisdiction. So they'll listen to a case, and then next thing, maybe the representative or the worker will make some throwaway comment. Workers and representatives, they love words like victimization and my constitutional rights, my conspiracy theories, that kind of thing. And then the commission will say, oh, right, I don't have jurisdiction. Goodbye. Off you go to the labor court. Right. 2 years, so the people go off to the labor court. They say, because the commissioner told us we must go to the labor court. They come now before me, 2 years, maybe 3 years. It takes long for a case to eventually get to trial in labor. So I'm sitting with this case and I'm saying, wow, hey, listen, I don't have jurisdiction. This case is a simple dismissal dispute for misconduct or whatever. What are you doing here? Now we're in a difficult position. And then the worker says, hey, the commissioner told us to come here. So you hear our case. They say, but I can't. The commissioner told us, you hear our case. Now we're in a difficult position. So I now have to either, strike the matter off the roll, explain I don't have jurisdiction, and revert it back to the CCMA. But the problem is, often with me, I'm sitting there and I start feeling bad. I feel sorry. Oh, shame. Now these people waited 2 years. Now I must send them back and so on. So I end up just sitting as an arbitrator, in terms of Section 157, and listening to these long, and in it, I'm getting very cross. And every day, I get very, very cross, thinking, that should have been there. Why am I sitting here? Okay, thank you.
Thank you very much, Judge. We can see your frustrations. Ladies and gentlemen, in your packs, we have there are USBs with all the presentations. The judge's presentation is not part of your packs, but the team is going to immediately start circulating to your emails the presentation that the judge went through. It was an informative presentation. Now, ladies and gentlemen, I'm not sure if there are questions. If there are, we can take questions. I'm sure Judge will have a few minutes for us to take few questions. By a show of hands, if there are any questions, unless if you're afraid to be reviewed. Okay. There's one hand at the front, Marcus.
Okay, thank you very much. Yeah, thank you very much, and I appreciate this presentation by the judge. Very, very quickly, I wanted to deal with the issue of following up the cases. If CCMA was a doctor, the doctor would say, in order to remain healthy, this is what you must eat, this is what you must not do, so that you don't get sick. But on the environment on the working place, there are so many things that are happening that are adversely affecting the employees. And they had to resort to the CCMA intervention in order to solve the problem. Now, on the example that she made about sexual harassment, most of the time when women are being the victims of rape or sexual harassment, they are under so much pressure to prove that they did not accept the advances. The question is, what is it that the women should do in order to send the clear message to say that I don't appreciate the advances? I remember of a case, and the judge, I think, and everyone would know, of a woman who lost the sexual case because there is no evidence of resisting. Most of the time we are told that if you are being robbed, threatened, people want to take your phone, your money and everything, don't resist. Just give that person the money, the phone and everything so that you save. Mm-hmm. But when it comes to the issue of rape, we put so much pressure on women that prove that we resisted. Why would not be acceptable, even on law, they are the expert in terms of law. Why would not be acceptable to say that the women said no? What is it they have to prove otherwise? That my no was so strong, was so hard. If a no is a no, then what is that she must do? Thank you very much.
Thank you. Marcus, can we have a roving mic to the judge? Okay.
Right, I think the code was, that's why they changed the code, because they were aware of the limitations of the 1998 code. Victims, men and women, we are all different. We got all different personalities. So, for example, if somebody says something inappropriate to me or want to do something inappropriate to me, I'm the kind of person who would say, immediately, tell them where to get off or even do something physical. But you get, so you get some women who are assertive, they're upfront. But you get certain certain women who, or men, and it's their personality. They're not assertive, they don't have, they're sensitive, right? And so they don't have that forthrightness. The fact that they keep quiet, and this is what that case that I referred to you, the fact that they keep quiet and just don't say anything to the perpetrator, but just walk away and so on, does not mean that's now a defense that he can use in his claim, because she does not have to prove. There's no requirement in the new act that the victim has to say to the person, expressly, overtly, indirectly, no. The code actually places the onus on the person to know what is right and what's wrong, right? That it's for you to know that what you're doing is right. It's not for someone to come and tell you, listen, this is not right. Right, so therefore, if the woman just ignores it and doesn't say anything, and then one day gets cutful, as this one woman did, after a few years actually, then she went to her friend and said to her friend, because people talk to their friends, she went to a friend and said, this is what's happening, it's been going on for many years. So that's how it came to management's attention, and then management investigated. And then when they got to him, they said, but what are you talking about? She never said anything. That's not the point. The point is what you did and what you should have known you should do. Okay, thanks.
Thank you. Two hands at the back, Marcus. I will start with Bomi. If you can get mic to Bomi.
Thank you. Just for the judge, on the issues pertaining to competent verdicts, I can't recall prior to this judgment an authority that gives the CCMA or an arbitrator the power to make a competent verdict. But with that being said, I just want to then refer to the Supreme Court of Appeal judgment that says that as arbitrators, we need to sort of focus on what the employee was dismissed for at the time of dismissal. Now, I'm worried now with this judgment, with the inconsistency with what is contained in the Supreme Court of Appeal judgment, because are we then not, when we start making competent verdicts on issues which the employee did not perhaps get an opportunity to respond to, for example, like the example you made where a dishonesty charge became a negligence charge and the person was dismissed for negligence, are we then not infringing on or would we not be infringing on employees' procedural rights and to a certain extent substantive fairness if we start making these competent verdicts? When do we draw the line in that respect? Thank you.
Thank you. My brother, you'll be the last one.
Thank you. Thank you very much. My question is with regard to the case of Chef versus Seaforth. The Labour Court decided on the issue of service level agreement and its interpretation. But I think we have a challenge here because the labor broker will simply make use of SLA as a mechanism to circumvent the interpretation of Section 198A to D, because the commissioner who actually dealt with this case is one of our commissioners in Ekurhuleni. We did discuss this in the case law monitor. And what I've picked up is that in dealing with Section 198A, my view is that we're entitled to go over and above to assess the nature in which the procured employees are employed in the workplace and make a determination. So now when we are limited into the interpretation of the SLA, it becomes a problem. It makes our work difficult. So I would like the judge to clarify on that issue. Thank you.
Thank you. Judge? Judge? Sure.
Was he asking a question about the definition of TES? Can you just repeat that last question? I didn't quite get it. Okay, well, before we do, let me just deal with this competent verdict. Let me just deal with the competent verdict issue. The important thing to remember is what this case is trying to say is don't get distracted by labels. The important thing is the factual allegations that were made from the beginning, right? Because when a person gives a charge, they obviously sometimes have like a heading, and then under the heading, they explain what you did, what you allegedly did. That is the focus, right? So if those factual allegations are proved, what it amounts to doesn't really matter. What the employer labeled it from the beginning or any time doesn't really matter. So that's what they are trying to say here. The focus is on the factual allegations. And if those factual allegations point to a dismissible misconduct or a sanctionable conduct, then that's fine. The only thing, obviously, that cannot change, those factual allegations can't change. So obviously, they can't charge you with one set of facts and set out those factual allegations, and then when they get to the CCMA, try and justify your dismissal on a completely different story. Basically, the story needs to remain the same. That's it. What the story is called is not important. I don't know, that's simple the way I can explain it.
Okay. Can you just repeat the question quickly, my brother?
Okay, thank you very much. Maybe I should broaden it a little bit. We do know that we are faced with a challenge with the TES. Now, in this case, CHEP versus CFOS, the CFOS relied on the service level agreement contract with the client. However, my view was that in dealing with Section 198 or finding application of Section 198 A to D, one needs to go to an extent where you assess the nature of the working relationship. For example, that might include an inspection in loco in order to be able to make an objective decision. But now, in this judgment, I think the interpretation there, or the principle there, is that as much as there's a service level agreement, we need to interpret it as it is and leave it at that. I'm having a problem with that. So I would like to ask a question the judge is that, isn't that making our life difficult? Because the mere fact there's a service level agreement does not mean that the employees who are presumed to be the employees of the service provider, which to me, sometimes we find that it is a TES. Isn't that a way in which the TES is circumventing the application or trying to dodge the application of Section 198 A to D?
All right, the simple answer is this. The LAC in that case is not saying that the service level agreement on its face is proof that there is no TES. Right. So you have the power in labor law to go behind that contract, all right, and to see and interrogate whether it is in fact just a normal service level agreement. Right? You don't have to take their word. They don't have to, if they come and just produce a written document and say, I've got a service level agreement, you have the power to interrogate the facts behind that service level agreement. What this case is saying, they're not saying, oh, because there's a service level agreement, you're not a TS. No, they're not saying that. They're saying you must interrogate the definition, the statutory definition of a TES. Look at those phrases. And the statutory definition of a TAS is that for something to be a TS, his business, his sole business, his main business must be to provide labor to a client. He doesn't have any other, he's not running a business of his own in something else, right? His sole business is the provision of labor. Now in this case, the person's business was not the provision of labor. He was running his own pallet business. Whoever need pallets to be maintained or to put up, that's what he did. That was his main business. So in that context, and that was the evidence, that was the proper evidence before him. So in that context, what he was providing, when he went to do a pallet business on behalf of a client, he wasn't taking his workers there to provide labor to ship. He was taking his workers there to provide labor for himself, to pursue his own business on the premises of the client. That's the difference. Okay. So the money that the supposed TS was getting was a reward, a fee for a product delivered, not labor delivered. Just read the case very carefully. You'll see it's not saying what you say it's saying. It's a very important case to read.